What does it feel like to sit in a cell and know that somewhere in a file you cannot access, there is a document that would set you free? I can tell you exactly what it feels like. It feels like cold. Not metaphorical cold, physical cold. The cell was always cold, a specific institutional cold that came from concrete and metal and the absence of anything soft, and I sat in it for 22 months carrying the certainty that something had gone wrong that I could not name, that the process had produced an outcome that was incorrect, and that the mechanism for correcting it was unavailable to me because I did not yet know where to look. My name does not matter for this story. What matters is the forensic report, the 3 pages that were missing from it, and what happened when a woman called Catherine contacted my appeal solicitor 18 months into my sentence. I had been convicted of fraud. The prosecution's case rested substantially on forensic evidence relating to digital files, metadata, access logs, a pattern of activity that the Crown's expert had described as consistent with deliberate manipulation. The expert was a forensic scientist called Dr. Holt. She was credible, qualified, and had given evidence in this type of case before. The jury had found her persuasive, so had I, which was the most disorienting part. I sat in that courtroom listening to her evidence and thought, I understand what she is saying, I know it describes activity on those files, and I know I did not do it. Those 2 things cannot both be true. The jury chose which one to believe. The original forensic report was 47 pages long. The version disclosed to my defence at trial was 44 pages long. I did not know this at the time. My barrister did not know this at the time. Nobody on my side knew this at the time because nobody had any reason to count the pages of a document. They had been provided in good faith as the complete document. The 3 missing pages were the appendix to the technical analysis. They contained Dr. Holt's own caveats, her qualifications, her uncertainty ranges, and critically, her notation that the access pattern she had described as consistent with deliberate manipulation was also consistent with a specific type of automated system behavior that she had encountered in one previous case. She had flagged this alternative interpretation. She had included it in her report. She had not been asked about it in court because her questioners did not know it was there. 2 minutes in. I want you to sit with that for a moment. An expert witness includes her own doubts in a report. Those doubts are removed from the version disclosed to the defence. She gives evidence without being asked about her doubts. A jury convicts on the basis of certainty the expert herself did not fully possess, and I sat in a cold cell for 22 months before anyone found the missing pages. Catherine was a former colleague of Dr. Holt, a forensic scientist herself, thorough and troubled by what she had observed over years of working in the same institution. She had seen, on a previous case, a disclosure bundle that had not included the full version of a report she knew had been longer. She had raised it internally and been told the omission was an administrative error. She had not been satisfied with that explanation. When my case received a small amount of press attention, following a miscarriage of Justice Charity's quarterly report, she recognised the pattern and contacted my appeals solicitor. My appeals solicitor was a woman called Miriam, a specialist in criminal appeals, with the particular quality of someone who has learned not to expect the system to correct itself, but has also learned that it sometimes does, and who operates in the space between those 2 facts with a patience that I found both calming and faintly terrifying. Miriam obtained the original unredacted report through a formal disclosure application under the Criminal Procedure and Investigations Act, 1996. The application was opposed. The opposition cited administrative privilege. Miriam declined to accept this. The application went to a judge. The judge ordered disclosure. The 3 pages arrived on a Tuesday morning. Miriam called me that afternoon and read me the relevant paragraph. Dr. Holt had written, in her own words, in a section that had not been shown to my jury, the pattern identified is consistent with deliberate manipulation, but cannot be distinguished with certainty from automated system behavior of the type documented in case reference. Investigators should consider whether independent verification of the access context is available before treating this analysis as definitive. Cannot be distinguished with certainty. Should consider independent verification before treating as definitive. The midpoint arrived when the prosecution, presented with Miriam's appeal grounds, offered a settlement. They proposed acknowledging that the disclosure had been incomplete and agreeing not to oppose the appeal in exchange for my acceptance that the original conviction would be formally quashed without a finding of deliberate wrongdoing. Miriam told me what accepting meant. I would be free, my record would be cleared, but there would be no formal finding that the prosecution had done anything wrong, no accountability, no acknowledgement that a report had been filed without its caveats, no investigation into how the 3 pages had not been in the disclosure bundle. I refused. The settlement offer was refused. Miriam had told me I could refuse. She had also told me that refusing meant a full appeal hearing, further delay, and a less certain outcome. I understood all of that. I refused anyway, not because I was certain of winning more, because I was not willing to walk out of the process in a way that allowed the process to tell itself that nothing had gone wrong. The appeal hearing was in October. Catherine gave evidence. She described, with the specific authority of a practitioner, what the missing appendix contained and why it was materially relevant to the evidence given at trial. Dr. Holt was present at the hearing. She did not dispute the existence of the caveats. She said she had understood them to be included in the disclosure. The court did not find that she had acted in bad faith. The court found that the disclosure process had failed and that my conviction was unsafe. Conviction quashed. Partial win. Partial because the investigation into how the pages were omitted is ongoing, which in the language of these processes means that it is moving slowly and may not reach a conclusion I would recognise as accountability. Partial because the 22 months are not returned to me. Partial because the cold of the cell is still a physical memory that arrives without warning in ordinary moments, in supermarkets, in the middle of the night, in any room that has concrete in it. The costly part is the 22 months, but there is another cost I did not expect, which is the difficulty of trusting processes after you have been inside one that failed you. I have a solicitor I trust completely. I have a charity that supported me throughout. I have Catherine, who is a stranger who did the right thing at professional risk to herself. And I have the 3 pages. I keep a copy, not because I need them, because they exist and they were real. And for 22 months nobody knew they were there, and now they do. And I need to be able to hold something that proves the gap was real and that it has been named. That is what the costly victory feels like, not triumph. The cold weight of being right about something that should never have needed to be proven.